court.
You may be seated. Welcome to the First District Court of Appeal. We essentially have one case with a lot of parties, but we will hear the case of Halifax Hospital Medical Center, North Broward, South Broward, School Board of Miami-Dade, Putnam, Sarasota County Hospital District, and Lee Memorial Health System versus the Office of the Attorney General. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
Leave the court. Mr. Jaco and I will present argument, I'm sure you'll be pleased to know, on behalf of all the appellants, and I will begin. The primary issue before this court is this: does the Attorney General have the power to extinguish legal claims of a government entity without their consent in connection with settlement of a case in which she is not representing them, in which they are not a party, in which she is neither seeking nor recovering anything on their behalf? That's the essential issue in the case. She claims that she has that power, but she presents this court with no grounds for the power. She instead offers the court a number of generalized statements from Florida courts and from other jurisdictions about the historic broad powers of the Attorney General. But we have two Florida Supreme Court cases that have closely addressed this question of her power: Holland v. Watson in 1943, and Watson v. Caldwell 3 years later in 1946. The Holland case involving the State Board of Administration, and the Watson case, the trustees of the Internal Improvement Fund. I mentioned that the names of both of them have been changed slightly, so I'm not making a mistake, but those are what they dealt with. And in those cases, the Attorney General in both of them, was claiming that he had the power to represent those agencies because he had this generalized common law power to represent all agencies and all governmental units of the state. The Supreme Court firmly rejected the argument in both cases. The important thing about the case is this: the Attorney General acknowledges that those cases continue to be the law of Florida. They've never been reversed. In fact, they've never been questioned. The Attorney General says, however, that that all those cases said was that the Attorney General has the right to represent those agencies, even though they have the right to hire their own counsel, but that nevertheless she has the right to extinguish the claims of those parties despite the fact that they're represented by other counsel. In the first place, that just makes no sense. It wouldn't make sense to say, well, they have the right to hire their own counsel, but the Attorney General can step in and undermine that counsel's decisions. But perhaps even more importantly was the grounds upon which Holland and Watson reached their decision. And what they said, in no uncertain terms, is that whatever powers the Attorney General of the state of Florida has, they must arise from either the Florida Constitution or Florida statutes. They must be delegated by the Florida legislature. That's what they said in those words. So if we look to the Florida Constitution, it says the Attorney General's powers are, quote, as prescribed by law. And if we look at the statute, it's section 16.015, it only says one thing. It says the Attorney General is responsible for providing services required by any department. Department is a term of law in the Florida Constitution. It provides that department is the principal administrative unit within the executive branch of state government, and it permits a maximum of 25.
Can I ask you about that, counsel? The Kress, Landis v. Kress case, predating the Watson case, that said the Attorney General retains common law powers, notwithstanding the statutes and Constitution that list or describe some of the powers that she has. Are you contending that that's no longer good law?
Not necessarily. The question is, what are the common law powers? I have several responses to that, as did the Supreme Court in Holland and Watson. One of them is, what is a common law power? The common law is simply the law as stated by a whole series of cases over years, and no case has ever said that the Attorney General has the power to extinguish the legal rights of a local governmental agency. Nobody's ever said that.
Mr. Richard, you might pull that microphone just slightly closer to you if you don't mind.
Like that?
And-
Maybe I
thank
can
you.
raise this a little bit.
And you can lower or raise that as you see fit?
Is that better?
I think that's better. And did
Sorry.
you reserve time for rebuttal?
Stop.
Did
Okay.
you reserve time for rebuttal?
Thank you, Your Honor. So, first of all, no common law case, and the Attorney General has been able to cite none that gives her the power, or even that had analogous circumstances in which she was held to have the power to do that. The second thing is that Holland and Watson rejected the argument that she had some kind of common law powers that gave her the ability to do something that is not grounded in the Constitution or the statutes of the state of Florida. Interestingly, in Watson, I think it was Watson, might have been Holland, the court pointed out that the legislature had the opportunity, or the framers of the Constitution had the opportunity to provide the Attorney General with the power he was then seeking and hadn't done so. Well, the Constitution we've adopted a whole new Constitution since then, and we've amended it multiple times. And it's never given the Attorney General any new powers since Holland and Watson. In addition,
The Constitution and the statutes, as I understand, don't ever say anything about parents patriae and the ability of the Attorney General to sue on behalf of the state. But you would agree that the Attorney General retains that power, that she can sue on behalf of the state in matters of public interest.
yes, absolutely.
Okay.
She has just, I'm sorry.
But that doesn't come from any statute or from the Constitution as far as I'm aware of. So it's got to be somewhere in the common law, right?
Well, she has some power, clearly. She is the general counsel for the state of Florida, and so in that capacity, it's common sense that she has the power to represent the state as an entity or state agencies when it's dealing. What the court said, the best example of it was Engel 2, in which the court said that the Attorney General, in that case, the argument was whether there was res judicata based upon the settlement, the tobacco settlement. The tobacco cases involved two things, a claim for compensatory and a claim for punitive damages. And the court separated the two.
Mr. Richard, may I just describe the landscape of the case, which I think is helpful for the context of the argument? And just to go over the facts very briefly, what occurred here was the Attorney General filed suit in the Sixth Circuit, correct?
I'm sorry?
The Attorney General filed suit in the Sixth Circuit, right?
Yes,
Your client and some of the other clients filed suit later against some of these same, we'll call them the opioid defendants, correct?
correct.
When the Attorney General filed suit in the Sixth Circuit, she never notified your clients, correct?
Correct.
She never asked for your client's permission, correct?
Correct.
She never offered to include your clients in any settlement, correct?
Correct.
Then after your clients filed suit, she later settled the case with these defendants, correct?
That's correct.
And then she filed a declaratory judgment in Leon County Circuit Court against your clients, asserting that she had the legal authority not only to settle any claims you might have had, but to actually extinguish all claims your clients had.
That's correct, Your Honor. And my client's claims, incidentally, were entirely different than the claims the Attorney General made. She was seeking to create a fund, and did create a fund, to mitigate these issues going forward. She sought no money to compensate any of the appellants for the actual losses that they suffered because of the opioid crisis.
And the argument she seems to be, or she is making, if I understand it correctly, is she has to sue your clients, who she never notified, never brought in, never included in a settlement. She has to sue your clients and extinguish any rights you may have thought you had in order to protect the $3.1 billion settlement. Is that right?
That's correct. As a matter of fact, the settlement that she entered into, clearly because the parties to that settlement weren't confident that she had the power to extinguish these rights, they created incentives for the parties to sign on to the agreement.
So the Attorney General goes to the Leon County Circuit Court and states she's in doubt as to her right to extinguish your client's claims and to represent your clients without their permission in order to effectuate the release on behalf of the opioid defendants, correct?
That's correct, Your Honor. In fact, in the settlement with the opioid defendants, she was required to file a lawsuit to do what she did, to stop anybody from getting another judgment.
And they haven't, the opioid defendants aren't here, are they?
No, they're not. And
they didn't file a declaratory judgment in circuit court, did they?
No, they didn't.
And they didn't file an affirmative defense of release, or did they? In your case is filed after the Attorney General filed her suit.
No, they did not. And what's more, the Attorney General made no effort to intervene in our suit to take the position that it was res judicata. There seems to be no suggestion that the Attorney General's settlement was res judicata, which of course it was not, because it didn't even seek the same compensation that our clients did.
Can I take you back to Engel? You were talking about that, and I agree with you that that's an important case. It talks about the ability, litigating the rights and interests common to the public at large, but that the state may not sue to assert the rights of private individuals. Are you contending that the subdivisions that we're dealing with as the appellants here are in the same position as private individuals, or are they the public at large, or are they something in between? And how is that decision made?
It depends upon what we're talking about. Our clients are not, I wouldn't call them private entities. They're not private entities. They're public entities, but they are independent entities that do not fall within, clearly don't fall within the administrative authority of the Department of Legal Affairs. The school boards were created under the Constitution, and they are independent bodies that the legislature can dictate rules to, but it has chosen not to, so far as this is concerned. And my clients are a constitutionally created organization that is governed by a board appointed by the governor. Neither of those two groups have any connection whatsoever to the Department of Legal Affairs. There are two cases I want to quickly comment on because the Attorney General relies upon them. One of them is Freed v. State, which she said that the local governmental bodies are creatures of the state. It did not actually say that. The term it used was that they're creatures of the legislature, and we don't deny that. The Attorney General has gone to the legislature, presumably 2 different years, 2021 and 2023, and asked the legislature to give her exactly the powers that she now claims, and it chose not to. And she made no effort to do it again in 2024. Unless the court has further questions, I want to make sure I save enough time for Mr. Jaco, who's going to cover some subjects that I did not. Thank you.
Thank you, Mr. Richard.
May it please the court. In your honor, I'm going to reserve 3 minutes for rebuttal.
All right, and I'll extend the time if I find it necessary for both parties.
Your honor mentioned the Kress case, and I'd like to follow up on that. That case dealt with the AG abating a nuisance, and the court has 2 key phrases that show up in all the older Fifth Circuit cases and Florida Supreme Court cases, and that is defining the AG's power either of the state or of the public interest. And in this situation, appellants are not of the state, and our claims are not of the public interest. And let me elaborate on those 2 points. First, in terms of why appellants are not state entities, in the Miami-Dade reply, pages 6 to 9, we walk through a number of district court cases, AG opinions, holding that school boards are not state entities, including this court's decision in School Board Collier County versus DOE, where this court said school boards exert local power. Also, Florida Statute 189.012, subsection 6, defines hospital districts as local government. Even the AG's summary judgment memorandum on page 65 says appellants are local government, quote, not part of state government. And as your honor knows from the Freed v. State case, which was City of Weston State here at this court, that was all about whether local subdivisions had separation of powers. And this court said no, because they're not state actors. Appellants are not state entities, and the AG cannot sue on our behalf as such. Second, we are not suing for any kind of public interest. We didn't bring our cases parents patriae. We didn't sue on behalf of the people of our districts. We sued on behalf of our particularized harms and claims. For instance, in this Schaefer affidavit, it talks about Lee Memorial's $40 million of unreimbursed costs from the opioid defendants. In the Burt affidavit, North Broward asserts that it gets only 17% of its budget from the state, and it's got unreimbursed costs caused by the opioid defendants on top of that. These are particularized harms, and Engel 2 is the on-point case to address this. Engel 2 dealt with the AG's tobacco settlement, and it said that settlement, quote, is a release and res judicata effect. And that's on page 1259 of the opinion. And that's important because the AG says her release and res judicata have nothing to do with each other. That's not what the Florida Supreme Court said in Engel 2. That's not what her case law in Michigan certified question, which is a release and res judicata case. In the recent Pennsylvania case, Commonwealth versus AG, release and res judicata. And even in the AG's summary judgment memorandum below, starting at page 41, she talks about her release as res judicata. The Engel 2 analysis is that we need to look at the claims and compare them. So in Engel 2, when the AG sued for everything under the sun, statutory claims, injunctive claims, negligence, the court said the AG could not sue for the individualized damages. And the court, and this is an important quote, said that the AG sues for interests common to the public at large. And in that, the court cited a 10th Circuit, federal 10th Circuit case, Statsky, which is the leading case in this area. And the Florida Supreme Court said, we agree with the reasoning of Statsky, quote, distinct individual causes of action are not precluded. When you look at Statsky, that's a Colorado settlement for the abatement of certain claims. And the court held the AG had no standing because those claims brought by individuals and corporations dealt with property damage and economic losses. That's exactly what we have here. So to answer your question, it's not just about—
But the Attorney General's response to your Engel argument is that those were private plaintiffs, and that you are not a private plaintiff, that although you receive 16, 17, 18% of the funding from the state legislature, that you are a mere creature. I think this is a fair characterization of their argument. You're a mere creature of the state. You're a subdivision. You have no rights under the law, despite the statute specifically giving you the right to sue and be sued, that you have no rights that she cannot extinguish at will because you're either a public or a quasi-public entity. Isn't that their argument?
That's their argument. So, Your Honor, a couple of things. In the Freed case, the quote, creatures of the state, comes from the Weaver case that this court decided in 1971, quoting, creatures of the legislature. And as we know, Freed versus State, and when this court handled it below, is all about legislative power. It's not about the authority of the Attorney General. Now, in terms of Engel 2, the Florida Supreme Court said explicitly, quote, we agree with the reasoning of Statsky. When you look at Statsky, Statsky says that the AG can't sue for these individual interests. And then it says, we define individual interests by those by which the AG has no standing. So it doesn't matter whether you're an individual or in Statsky, whether you're a corporation or whether you're a subdivision, as long as the AG has no standing to sue for non-public interest claims, then she can't settle them.
In making the determination as to what is and isn't public, are we looking at the causes of action that your clients have alleged and that the AG has alleged? Or are we looking at the recovery that you're seeking to get, regardless of whether it's public nuisance or RICO or whatever? It's just what you're trying to do with the money. How do we decide that?
Your Honor, that is done by a res judicata analysis. That's what Engel 2 says. That's what all of the AG cases, whether it's certified question, the Nash v. Biltmore, the Divine First People case, the Commonwealth versus AG, all those cases are res judicata. So the way to do it is to assess whether there is privity, identity of parties between the AG and appellants. She can sue for things of public interest. If we're suing for things that are not of the public interest, but they're our own particularized, individualized harms and damages, she can't sue for those. And so if she can't sue for them, she can't release them. I would like to make it clear, though, that Engel 2 is consistent with the older Fifth Circuit and Florida Supreme Court cases. All of those cases talk about what the Attorney General's
Let
sovereign...
me ask you a hypothetical that seems relevant to the Attorney General's argument. Let's assume there's a future Attorney General with a different viewpoint, shall we say? And let's say this Attorney General decides to sue every cattle rancher in the state of Florida for causing climate change. And he or she sues on behalf of the state of Florida. The governor has a press conference and says, I oppose this. This is not my view. The speaker and the president of the legislature say this is not our view, but the Attorney General says this is my power. I represent the people of the state of Florida. I'm going to sue every cattle rancher in the state of Florida for causing, allegedly, climate change. And let's say a county, a rural county that is dominated by cattle ranching, files an objection or attempts to say, to file a motion that says, no, you can't represent our interest here. We actually love and support our cattle ranchers, and we don't want to have this lawsuit proceed. Under her theory, can she declare that it doesn't matter whether you object to this lawsuit? I'm suing for the behalf of the public interest for the alleged climate change, and my lawsuit will proceed. I may send you a check out of the settlement. You can cash it if you wish, but I'm going to file this lawsuit regardless of your objection. Is that possible under her theory?
That's right. Under her theory, at her own say-so, she could wipe away the county's claims, their standing, their defenses, whatever.
So
that,
can she represent a local subdivision against their interests?
presumably, yes, under this theory. Under this theory, she has the say-so over all political subdivisions because she defines political subdivisions as state entities. So she can take their legal claims and dispense
I mean, there doesn't seem to be a real limit to the power of her theory, of her ability to file suit for, quote, the people of the state of Florida, or am I missing something?
That's true. I mean, she claims this is sovereign power, so she herself dictates it.
And by doing that, is she essentially exercising the powers of the governor?
Well, Your Honor, she would say, I presume, in the field of litigation, that's her sovereignty and no one else's. So she gets to make the decisions of the state. But that's not what the older cases say, right? The older cases, they give her a tremendous...
In fact, in other states, attorneys generals have filed those types of suits, correct?
Well,
and asserted that their common law power means they have the power to make that essential policy decision to sue farmers, ranchers, other entities for damages on behalf of the people of that state, correct?
Correct. But what's really important to distinguish is in the cases that she mentions, it's all a statutory basis for the Attorney General to act. So if you look at the certified question case, which is the Michigan case, there's a Michigan law, 14.28, that says the AG has discretion to decide what's in the state interest and what's in the local interest. We don't have that kind of statute in Florida. I mean, she says that Florida statute 16.017 is something like that. But that's a general ministerial power statute. It's not specific like in these other cases. In her, Nash v. Biltmore case, There's a particular North Carolina statute that gives her the ability to step into the shoes of counties. And we don't have that here. Same in Illinois in the Devine versus People case. Specific Illinois statute gives the AG the exclusive authority to do this kind of release. But here, not only do we not have that statute, Engel too said the way to do it is through a res judicata analysis. And that remains with the courts, so that the AG doesn't have this power.
Will you clarify what you characterize as the res judicata argument?
Sure. So the issue before the Supreme Court in Engel 2 was a release.
I know what Engel 2 holds.
Okay.
We all do, I'm sure.
Okay.
How do you think res judicata applies here?
Well, what the court says is that the proper analysis on whether the AG is or is not suing for the public interest is to match up the claims, to match up her claims, what she settled for, what she claims to release, and our claims, and see if our claims are within her power. That's the question.
Do you concede that any of your claims are within her power?
Your Honor, we don't know because the trial court failed to do this analysis. I mean,
And isn't that a matter for the litigation to proceed in the other courts? Those other courts will have to make that determination, correct?
that's right.
Assuming we decide in your favor.
That's right. I mean, all
And by
the,
the way, if we decide in your favor, we don't reach the takings argument, correct?
that's right. The takings argument is a complementary argument to this, so that's correct. But that's right. In all of these states, Michigan, North Carolina, Illinois, Pennsylvania, they're all res judicata cases. So they're all cases in which the courts said that the AG and the other party, whether it's a state attorney or district attorney or a county, the question is, are they bringing the same claims by the same party? And what we're saying here is we are not the same party because we're not the state and our claims are not within the public interest.
Right, but you would agree that, maybe I have this wrong, but the Attorney General is not relying on a res judicata analysis to extinguish your claims. They're simply relying on their power, her power as a state chief judicial officer to step in to a political subdivisions lawsuit and extinguish it because of the state. And it's a power issue more than a res judicata issue. Is that your understanding?
That's right, and what's funny about that is she says there's no connection between her release, her power, and res judicata, but then all the cases she cites are actually res judicata questions, right? So every case, out-of-state case, again, I'll list them: certified question, Devine, Nash, the case she filed a supplemental authority recently from Pennsylvania, all those are res judicata cases. So there is a connection, undoubtedly, and Engel 2 is the on-point precedent for that. I'll reserve.
I'll give you an additional 10 minutes, and we'll allocate an additional 10 minutes to the Attorney General. That would be, I believe, 7 minutes and 42 seconds additional for you.
And, Your Honor, is that rebuttal time you'd like me to
Yes.
use? Okay.
Or you may use it however you see fit.
I'll save it for rebuttal. Thank you.
Good afternoon, Your Honors, and may it please the Court. For as long as Florida has been a state, it has entrusted its Attorney General with broad and flexible power to vindicate the state's legal claims. That authority ensures that a statewide elected officer can respond to statewide problems with a comprehensive legal strategy that maximizes recovery for the state and its citizens. The Attorney General exercised that power here to release claims inhering in the state's political subdivisions in exchange for over $3 billion to abate Florida's opioid crisis. That decision was well within her authority for two reasons. First, the Attorney General is entrusted to manage the legal claims of the state of Florida, but Exxon teaches that the state of Florida is not a free-floating entity. It is simply comprised of its constituent parts, and that includes its political subdivisions.
You're Mr. Costello, is that correct?
Yes, Your Honor.
Thank you.
Okay. It is simply the sum of its constituent parts. And at the end of the day, subdivision legal claims are the state of Florida's legal claims. And the Attorney General, when she is acting as the state of Florida, may pursue and settle those claims as necessary to vindicate the public interest. Second, the legislature can, of course, narrow the Attorney General's litigation authority when acting as the state, but my friends must provide clear evidence that the legislature has done so for these claims and these parties, and they have not come close to meeting that burden. I'd like to sketch out our general theory of how this court should think about these issues and then show my work for how we get there. The general theory is that the Attorney General, when she is acting as the chief state legal officer and the state's legal arm, can pursue claims of the state of Florida, and that includes all of its many constituent parts. But I want to be clear, that's subject to an important exception. And the exception is that the Constitution or the legislature can carve out a piece of the state's litigation power and place it in the exclusive control of a different state actor. I think an example of that is when the legislature passes a law that says the Department of Business and Professional Regulation shall enforce the state's gambling laws. That specific grant of power to a specific state actor indicates that the legislature has removed that piece of the state's litigation authority from the Attorney General's superior domain and placed it in the exclusive control of another state actor.
Can I ask you about that? All of the appellants here have some authority somewhere, either special law or general law, to sue and be sued, to contract, those kind of things. Why is the Attorney General able then to say, well, you can sue, but I can sue too, and my ability to sue trumps your ability to sue?
Sure, of course, Your Honor. So first thing, if we're at this point in the argument, I think you would have accepted that there's some general power that the Attorney General has to pursue the state's legal claims. The question then becomes, has the legislature abrogated that power? And my friends have to deal with the presumption against implied repeals and the presumption against common law abrogation. They have to show clear evidence that the power has been abrogated. And the general power to sue and be sued doesn't do that. It just establishes that an entity is a body politic and can operate autonomously, but it certainly doesn't say that its litigation power is exclusive. And I want to make this point because I think it's pretty important. If that's true, that means that there is virtually no legal claim or no injury that the Attorney General, when she's suing as the state, can represent, because almost every actor in the state of Florida, every governmental entity, has the power to sue and be sued as a general matter. So that it cannot be the case that that suffices to establish abrogation.
Well, let me turn it around the other way then. The Attorney General claims the ability to step in and sue then on behalf of the state, even if the parties don't want that. How far does that go? So all of the appellants take state money or are entitled to state money through the budget. So the Attorney General certainly wants to protect the state money. So if a doctor at a hospital is suing over a breach of contract, can the Attorney General step in and say, well, the state money's at risk. I'm going to take this litigation over. I'm going to sue. I'm going to settle. I'm going to do whatever I want to do. And the hospital has no say.
Sure. So, Your Honor, the answer to your question is generally yes. If the Attorney General wanted to exercise that authority, assuming that doctor is a state doctor, she could do that, assuming there is no abrogation from the legislature or the Constitution saying that particular state actor.
So even if, for example, Shands Hospital has a doctor that sues Shands Hospital, let's say over a fee dispute, the Attorney General can step in and tell Shands Hospital, assuming they're a special hospital district like some of these clients here, no, we're going to represent your interest in this case. We're going to settle. We're going to pay the doctor $1 million. You were in the wrong, and that's the end of it.
No, Your Honor. I want to be clear about how the Attorney General's authority would operate in a defensive posture, which I think your hypothetical is getting at. She certainly could, if she thought it was in the public interest, intervene on behalf of the state in that case. But she would be representing not Shands, because Holland and Watson say she can't do that. Instead, she would be representing the state of Florida as a party, and then
But the state of Florida is not a party in that hypothetical.
of course, Your Honor, but if she intervened, she would be intervening as the state of Florida as a party.
So she can inject herself as as a state party in any type of litigation in the state of Florida?
Well, that's certainly true because, of course, in the end, all governmental actors are state governmental actors. They're exercising the state's sovereign power, and she is the chief state legal officer. But I want to be clear, though, that it's very unlikely that your hypothetical is going to come to pass, that the Attorney General is just going to parachute in and defend these claims.
What about my other hypothetical? Do you think that might come to pass? And if it, let's not speculate on whether it might come to pass. Do you think if it did come to pass, the Attorney General would have that authority?
I think
to represent the people of the state of Florida in this hypothetical Attorney General's view that farming is a dire risk. Let's assume this Attorney General has a certain view about climate change, that she or he thinks that it's in danger by human activities. So she's going to sue every cattle rancher in the state of Florida on behalf of the people of the state. The governor holds a press conference and says, I totally object to this litigation. This is not my view. The Speaker of the House, the President of the Senate, this is not the view of the legislature, but the Attorney General says it is my view, and I'm going to sue because the climate of the entire state of Florida is being threatened by farming. How is that not allowed under your theory?
Well, Your Honor, it certainly is allowed under our theory, but I want to be clear that there are many checks that ensure that the Attorney General is acting within her proper role. One of them, to use Your Honor's hypothetical, would be a legislative check. If the legislature disagreed with her lawsuit, it can pass a statute saying you can't bring this lawsuit. More importantly, though, I think you have to conceptualize that this happens all the time. You know, if I can just flip Your Honor's hypothetical slightly, the Attorney General sues the federal government on behalf of the state of Florida all the time, most recently for failing to enforce the state's immigration laws. When she does that, she asserts injuries to the cities and counties in the state of Florida that are suffering the brunt of the immigration crisis. So she'll assert the injuries of, say, the city of Miami. And it certainly could be the case that the city of Miami might object politically to that decision. But of course, no one thinks the Attorney General cannot assert those injuries in her lawsuit against the federal government when she's acting as the state.
Is that basically a parens patriae claim that she's acting, on behalf of the state? She's not suing for Miami-Dade's individual interest, any kind of particularized damages. She's saying, on behalf of the state, we're looking for X.
No, Your Honor, it's not parens patriae, and I think this is an important point because there's some confusions in the brief. Parens patriae is the specific power of the sovereign as a parent to bring claims on behalf of its citizens. It's not a power that allows the sovereign to bring claims on behalf of itself. That's the power the Attorney General asserts when she sues for the state of Florida against the federal government or when she releases claims of the state of Florida in litigation against private companies. Parens patriae is not the lens to view this case. She didn't use or need to use the parens patriae power. She used her power as chief state legal officer to manage the state of Florida's legal claims. And my friends, try as they might, are actors in the state of Florida wielding government power. Their claims are the state's legal claims.
Well, going back to the doctor hypothetical that I gave you and that Judge Thomas expanded on, how far then can that go through injunctions, deck actions, friendly suits? It seems like the Attorney General could basically run any of these people if a benevolent, not this Attorney General, but a future Attorney General chose to step in the shoes through litigation, basically control them.
Yeah, it certainly wouldn't be this Attorney General, but I take the question. So two things, Your Honor. In a defensive side posture, the mechanics of how this would work is that any judgment that the Attorney General acting as the state would agree to, any settlement she would agree to, would act against the state of Florida as a party, not against Shands Hospital. So if there's some sort of injunctive relief, it runs against the state, but injunctions can only run against actors, so it's not really clear that there's going to be any concern of injunctive relief. But I do think it's important here to ground ourselves in the checks that ensure that your hypotheticals won't come to pass, because Justice Ervin in Yarborough recognized this. He recognized that the Attorney General's power is quite broad, but it's subject to important checks to assure it's not abused. And there are three that I'd like to sketch out. I think they're quite important. The first one, of course, as I mentioned to Judge Thomas, is a legislative check. The Attorney General wields her litigation authority on behalf of the state, subject always to the legislature's ability to confine that authority with specific statutes. The second check is a political check. The Attorney General is a statewide elected officer. If she abuses her power, she has to face the voters at the polls. The good news, though, is that it's unlikely that that's going to come to pass because, as Gleason tells us, the Attorney General's office is a position of a public trust. And generally, the citizens are going to get it right the first time. They're going to put someone in office who wields her power responsibly. And I think the fact that
Well, in my hypothetical, the Attorney General might very well, for his or her particular viewpoints, assert and sincerely believe that he or she is protecting the citizens' interests, that it's a public trust to stop farmers, allegedly, this is a hypothetical, from causing climate change, and therefore she's going to sue every farmer in the state of Florida. The idea that the legislature can check it by passing a statute, quite frankly, anyone familiar with the legislative process knows it's not so easy to pass a statute. And it can take time, and it cannot happen for a variety of reasons. It requires actions by all elected legislators. And so, so your check would be then, well, at the next session, they could affect her budget, or his, in this hypothetical, or at the next election, if the voters decide that's not in their particular policy preference, they can vote against her. But doesn't that essentially concede that what you're arguing for is a policy power?
No, it's not, Your Honor. It's a litigation power. Again, the Attorney General does this all the time. She sues the federal government on behalf of the state for failing to enforce the laws. She sues the tobacco companies in the 1990s for committing grievous harms against the state of Florida. Your Honor's hypothetical simply recognizes that sometimes the state has to speak with one voice when it comes to its litigation power, and the state has placed that power in the hands of the statewide elected Attorney General.
But here, you don't dispute any of the facts as I laid them out earlier, correct?
Not at all, Your Honor.
You filed suit, the Attorney General, the Department of Legal Affairs, filed suit against the opioid defendants. You did not provide notice to these clients, correct?
No, we did not.
You did not invite the clients to participate in the litigation, correct?
No, we did not.
You did not advise or consent or seek consent from the clients regarding their particular claims.
No, we did not.
And then when they filed suit to protect their interest, you filed this action for declaratory judgment, in essence to enforce a release on behalf of the opioid defendants, correct?
Not exactly, Your Honor. I mean, our settlement agreements require us in good faith to seek a judicial bar to try to get the benefit of incentive payments to the state of Florida.
But why not tell the opioid, well, I know that's part of the settlement, but shouldn't it have been the opioid defendants' responsibility to seek to enforce their own release? They obtained a release from you. They paid you a certain amount of money. As part of that agreement, you agreed, or they demanded an agreement that no other lawsuits would be filed against them, correct?
That is correct.
And so that is a release, correct? An
That is right.
affirmative defense.
It certainly is.
It could be raised in some of this other litigation.
That's right, Your Honor, but we have a controversy here. You're totally correct that the opioid defendants are well within their rights to assert release in their own litigation.
And they still can, if this court rules in their favor and that litigation continues, they can assert those releases, correct?
Well, it depends on how this court drafts the opinion. If this court says the Attorney General doesn't have the power to release the claims, then they can't do that. If this court says this isn't the proper procedure, then I suppose they can. But I want to push back against that thought, Your Honor, I think that's somewhat of a standing argument, that this is not there's no real dispute between the parties here, but there absolutely is a dispute. Our settlement agreements say if you don't get a judicial bar, then the state of Florida suffers substantial financial losses and potential incentive payments for opioid victims. So,
I'm sorry, Judge. You go ahead.
Am I correct that the substantial financial losses would amount to around $27 million out of a $3.1 billion settlement?
that is at the minimum, but I want to be clear that it could be quite more than that. So the way that the incentive payments work is if any of these these subdivisions are able to recover or as a general matter, if they're able to recover against the opioid defendants, our settlement is subtracted dollar for dollar. They get a $100 million judgment, that's $100 million less that goes into this settlement that, by the way, is being allocated to the cities and counties to give out to opioid victims.
But not to the hospital districts or school boards.
Well, the hospital districts are within the cities and counties, Your Honor, that have been given the money to disperse to people to abate the opioid epidemic. My friends can go to the cities and counties, they can ask for that money. To my understanding, they have not done that. They also can go to the legislature, by the way. And this is another check that I think gets at your concern, Judge Thomas, is that if there's a concern that the AG settlement might leave a subdivision hanging high and dry, they can go to the legislature and ask the legislature to recoup their budgets. They have not done that in this case. But in this case, it's even easier. They can just go to the cities and counties that are getting the money. I also want
But
to
they can also go to court. That's what courts are for. The courts are here to adjudicate disputes between parties. If the Attorney General was seeking to represent these clients that are here at our court today, why not file the lawsuit on behalf of the hospital districts, the school boards? Why not name every party that the Attorney General seeks to protect in the lawsuit filed in the Sixth Circuit?
Your Honor,
And contact the clients and say, we're filing this lawsuit, tell us what your damages are, we will seek those damages, let's work together.
yeah. Your Honor,
Isn't that the way to proceed in terms of the way lawsuits work?
it is not, Your Honor, and let me explain why. That rests on a fundamental misconception about the Attorney General's authority that I think stems from my friend's discussion of Holland and Watson. When the Attorney General sues for the state of Florida, the state of Florida is the party. The state of Florida is the client. She does not have the power to represent individual political subdivisions as parties in lawsuits. That's what Holland was very concerned about. It didn't want the Attorney General to be able to force subdivisions to pay her money to represent them in court. Instead, Holland and Watson distinguish the Attorney General's power to force representation from her power to sue for the state of Florida as a party and represent the state of Florida in litigation. And when she does that, she can assert legal claims arising out of the state's constituent parts. And if I can ground this, if I may, in a practical example and a good bit of tradition, the Attorney General did this in the tobacco litigation. And I think that litigation is quite important and parallel to here. In the tobacco litigation, she sued for the state of Florida and all of its subdivisions. And when
Wasn't the tobacco litigation supported by statutory authorities, specific statutory authorities?
That's certainly true, Your Honor, but when she settled the lawsuit, she released the claims of the state of Florida, not just the claims that she was authorized to bring by statute, but she released the claims, all claims that the state of Florida could bring, including its subdivisions. I don't think that anyone, after the tobacco settlement was signed, thought that every single subdivision could have sued the tobacco companies for hundreds of millions of dollars. It would have been quite unclear what the tobacco companies were even settling in that circumstance if the Attorney General, when acting as the state of Florida, was unable to settle legal claims arising out of the state of Florida's constituent parts. I don't know how the tobacco settlement would have even worked. And again, I really do want to underscore that if this court were to hold that the Attorney General is not able, when she's acting as the state, to pursue claims arising out of the state's constituent parts. That means, for example, when the Attorney General sued the federal government for shutting down the cruise industry, she was unable to assert as an injury that the Florida port authorities were not getting funding because the cruise industry was shut down. Port authorities are just political subdivisions. In that lawsuit, she asserted successfully in federal district court.
Did the port authorities object?
The port authorities did not object, but it doesn't matter whether—
Did she notify or he notify the port authorities?
I'm unaware whether there was notification, but again, it doesn't matter if she did, because when she is acting as the state of Florida in litigation, the state of Florida doesn't need to notify its constituent parts that it is pursuing one of the state of Florida's claims, one of the state of Florida's injuries. And I want to also underscore the severe resource suck that I think Your Honor's hypothetical would get at, because it can't be the case that whenever the Attorney General sues for the state of Florida, she has to notify every single constituent part to make sure that they can—
But doesn't an attorney have to notify a client if they're going to sue on behalf of the client?
Your Honor, I think, again, that gets—
I mean, isn't what we're talking about here really we're talking at an abstract level, but we're really talking about the attorney-client relationship, correct?
We absolutely are not, Your Honor, because again, Holland and Watson tell us that the Attorney General cannot represent subdivisions as parties in lawsuits, but the Attorney General certainly can represent the state of Florida. That's exactly how Exxon distinguishes Holland and Watson. Exxon recognizes that the Attorney General, when suing on behalf of the state, can sue for injuries arising out of its departments, agencies, and yes, political subdivisions.
But isn't Exxon distinguishable? Well, first of all, it's a U.S. Circuit case, so it's not binding on us. But isn't it distinguishable in that there was no objection from any of the subdivisions there? And in fact, there was a discussion that the subdivisions were likely to receive some of the proceeds from whatever the AG eventually got.
So 2 responses to that. You are correct that Exxon is non-binding, but we're not asking the court to follow it because it's binding. We're asking the court to follow it because it's right. It correctly construes Florida law and runs through all of the case law that we discuss in our briefs. But second, to your point about the objection, I think a fair read of the case shows that that was more a practical point, a perceived fairness point. The court was simply saying, what's the big deal? No one is objecting here. But nothing in Exxon suggests that the court's holding turned on that. In fact, that point came after Exxon's analysis of Holland and Watson, where the court says, look, Holland and Watson provide no bar whatsoever here. And if you were right that Exxon would have changed different, or would have turned out differently, based on the subdivisions objecting, that means that when the Attorney General sues for the state of Florida against the Biden administration for refusing to enforce the immigration laws, the city of Miami can opt out of the lawsuit. Any subdivision that disagrees with her decision as chief state legal officer elected by the public to bring a lawsuit on behalf of the state can opt out and object and make it infinitely harder to obtain a standing in federal court. I also want to underscore that if what my friends are saying is true, it becomes quite difficult to obtain an orderly settlement for the state of Florida. Because attorneys general, and we cite some law review articles to this effect in our brief, when they are acting as the state, have the ability to provide global peace to defendants, and that increases the value of their settlement agreement. If they do not have the ability to provide that peace, defendants are far less likely to settle with the state, because what is the state even offering? If after that settlement, every single subdivision can go and bring all of their own claims. So it will make it infinitely harder, if this court were to adopt my friend's theory, to bring those types of lawsuits on behalf of the state of Florida and obtain recovery for Florida's citizens. Also, it would be a substantial resource suck, because when the Attorney General brings a lawsuit, it's one office, it's one taxpayer-funded entity that is pursuing an orderly litigation against a defendant. On my friend's theory, it's 100 offices. It's 1,000 subdivisions with all their own lawyers bringing all their own claims, costing taxpayers more and more money.
But doesn't that just go to the nature of the case? I mean, here the opioid defendants could have told the Attorney General, if it was in their interest, look, we know we've got claims that are likely coming down the chute, so to speak, from hospital districts, school boards, et cetera. We need a global settlement that involves all these clients. We need all of them involved. We need all of them to sign off on the agreement. Isn't that the way it probably should work?
No, Your Honor, I disagree respectfully, because I think that the situation I posited just to you before would occur, I think, quite often. The city of Miami, if it disagrees politically, will object, and you won't be able to get everyone on board, and you will still have all these holdouts that will be able to pursue all their own claims. It's quite difficult to imagine the scenario where
the opioid defendants here could be worse off if they don't agree. They could end up paying more money to the other entities, and in addition to whatever settlement they reach with the state of Florida. I mean, everyone has their own interest, and they're willing and quite able to protect their own interests. The question here is, does the Attorney General have the authority to to exclude these clients from the litigation, file a settlement that they assert is adverse to their interests, not even notify them, and then announce later on, not only are you not a part of this settlement, you're not getting any proceeds, and we're going to go to Leon County Circuit Court and attempt to block you from having any right to proceed with your litigation. That's what's happening here, right?
Your Honor, I wouldn't put it in exactly quite those terms, but I don't
But
want...
factually, that's what happened.
You're right, that's what's happening here, but I also don't want to run from the question, because the Attorney General, when acting as the state of Florida, must have the ability to do exactly that, to ensure orderly litigation brought on behalf of the state. And I think also, and I want to be clear about this, your question, it rests on a misconception about my friend's legal claims and their connection to them. You know, I think your question assumes that their legal claims are their private and personal claims that they have a specific interest in.
Well, for example, one of the school boards asserts that it has had to expend money under the federal statute for teaching, I believe it's disabled children, that some of these children have been disabled by opioid addiction and/or other aspects of the opioid crisis, that they've had to expend money specifically under that federal statute. Your response seems to be, well, you can go to the county commission. We did give Broward County a piece of the settlement. You can ask them for reimbursement. Isn't that your position?
That is our position, but I want to be clear that the money that my friends have spent, those injuries that they've suffered, are not their private injuries. They're not their personal injuries. They're the state of Florida's injuries. Everyone here is a government actor. They are wielding the government's power. The question is, we all know in the end that these are the state of Florida's legal claims. They're not the subdivision's legal private claims, they're the state of Florida's legal claims. The question, and the question here is, who has the state of Florida endowed?
Well, I think that's not a correct assessment of their position. Their position is that's not a state claim. Their position, that's an individualized claim of that particular school district, or Broward Hospital District might have specific claims. All that can be litigated in the future in terms of either res judicata and/or accord and settlement. I assume that might come up. But they're asserting that they have specific claims based on the nature of their entity, whether it's a hospital district or a school board, and that the Attorney General doesn't have the authority to simply assert, oh, well, those are state claims. We settled it. We didn't notify you because we don't need to notify you. We didn't reimburse you because we don't need to reimburse you. And that's the way it works.
Let me be clear about what I mean when I use the word state. I don't mean the word state in the sense of state government versus local government. That's not what the cases mean when they talk about the AG's power to sue for the state of Florida. I'm talking about the state as an entity. And government actors that are wielding the state's sovereign power are part of the state as an entity. If I can give you an example, if the Attorney General's office opened a gift shop on the first floor of the Attorney General's office, and there was a breach of contract suit involving that gift shop, that's the state of Florida's breach of contract suit. It doesn't matter if it's proprietary or personal or individualized. These are government actors. In the end, their claims are the state of Florida's claims. The question is, who has the state allocated superior power when the public interest requires it to litigate and settle those claims to advance the public interest? Cases like Kress, Yarborough, and Exxon tell us that it is the Attorney General. And there are checks to ensure that she does not abuse that power. The legislative check I mentioned before, the political check, and of course, the practical check.
When you cite Yarborough, that's really Justice Ervin's concurrence, right?
I also mean the majority.
The court, though, didn't go as far as Justice Ervin, who basically gives the AG unquestioned authority.
Well, I think that Justice Ervin was recognizing that the AG's authority needs to be broad, but I want to address your question directly. We're also relying on the majority in Yarborough because the majority in Yarborough acknowledges that the Attorney General can sue for the state of Florida, quote, as a consumer. But Exxon recognizes that when the state sues as a consumer, there's no free-floating state. The state is just comprised of all of its local independent parts that suffer injuries in a consumer-based capacity. When the AG sues as the state of Florida as a consumer, she is asserting the claims and injuries of all of those constituent parts, like my friends.
If the AG decides that something is in the public interest, is that subject to any challenge anywhere? Or does she have unfettered discretion in saying, this is in the public interest, we're going this direction, no court or anybody other than potentially the legislature can stop me?
Your Honor, I think this court's decision in Barati quoting, I believe, Gleason, says exactly that.
Well, Barati was a quietam, so I mean, that, I don't think Barati
Well,
itself
Barati-
applies.
You're right, Your Honor, but Barati, of course, relied in part on the Attorney General's common law authority. There's a whole part of the opinion at the end that relies on her common law power, and it says that the Attorney General's determination that a legal action of the state is in the public interest is a judicial act that is effectively unreviewable. Now, I don't think we need to press that argument to win here, because I think that this case indisputably involves something that would fall within the public interest, and that's using the state's litigation power to abate Florida's opioid crisis. So if there's any limit or check from the judiciary, I don't think this case even comes close to reaching the outer bounds of her discretionary powers. But I do want to reserve that Barati says that the power is effectively unreviewable in courts and is better left for the legislature. If I may, I recognize that that this court may not be inclined to reach the maximum extent of our position, though we certainly think it's right. What I would say is what this court could do instead is say, look, we don't need to sketch out the outer bounds of the Attorney General's power. None of the cases try to do that. Instead, what we'll do is determine that the Attorney General, at least when she is acting to remedy and abate a statewide harm, can litigate claims for the state of Florida and pursue injuries and claims arising out of the state of Florida's constituent parts. And I don't think anyone disagrees in this case, and it would be quite difficult to, given Governor Scott's declaration, that the opioid crisis is a statewide harm. So if ever there were a case where the Attorney General, while acting as the state, can pursue claims arising out of the state's subdivisions, it would be a case like this one. It was just that exact kind of case in the tobacco litigation, and indeed, I think a Pennsylvania court just acknowledged that the Attorney General could sue for the state of Pennsylvania in an opioid case. And that's exactly the distinction I think this court could draw, would be the distinction that the Michigan court drew in recertified question. I'd urge, of course, the court not to reach to say that that's the limit of the AG's power. No courts try to sketch out all the breadth of the AG's power, but that is a way that this court can limit its holding.
The Pennsylvania and Michigan cases were both based on state statutes, right? That the Attorney General had some specific authority granted to him or her by a state statute, whereas here you seem to be relying on just the common law authority, although perhaps for the RICO and the FDUPTA claims, there may be statutory authority.
So, yes, we are relying on RICO and FDUPA, and yes, we are relying on the common law, but we are not just relying on that. Florida's common law power, the Florida Attorney General's common law power is statutized. It exists in section 1601, subsection 7, that says she shall have all the powers usual and incident to her office. So that's very much like the Michigan case. The Michigan case, I believe the statute says she gets to intervene and pursue litigation for the state when she determines it's in the public interest. The legislature has just sort of cut a shortcut and said the Attorney General has all the powers inherent in her office at common law, and that would include the power to pursue litigation for the state when the public interest requires it. That's exactly what Crest says. If this court has no further questions on the on the abrogation issue, I'd like to touch briefly on the takings claim, and I'm happy to address any questions about it. But I think the takings argument is as simple as the takings clause requires compensation when the state takes private property from an owner of private property. The subdivisions do not own private property. They are state actors. They hold public property in trust for the state of Florida. So the takings clause just doesn't apply to them, and we've cited many, many cases in our briefs acknowledging that.
The US v. 50 acres of land seems to expand the definition of private property to include public and municipal property.
I believe that case, Your Honor, was talking about the distinction between the federal government and the state government. And
it is a U.S. Supreme Court case.
Right, and that's very important, of course, because as to the federal government, the state of Florida's property is, of course, private property. If the federal government tried to take some of the state's property, we would absolutely bring a takings claim. But that's because there are different sovereigns. The federal government is a stranger in town when it comes to the state of Florida's property. That doesn't exist when everything that is involved in the litigation is the state of Florida's property.
And I'm sorry, go ahead. Good.
Sorry. It dawns on me, I forget, the West Palm Beach, there was one case involving the city of West Palm Beach, where I think the Department of Transportation was attempting to take some property. And it's clearly is a governmental entity, and it's not for the federal government versus state government. It's a subdivision of the state government. Is that consistent with your argument?
No, it is inconsistent with our argument. One, in the West Palm case, no one even raised this argument. The court just assumed that the takings clause applies to intergovernmental takings. There was no discussion of this theory. And two, in another case, in fact, in the Dade County case that my friends cite, the Department of Transportation made exactly the argument that we're making now. The court recognizes it in the opinion that the DOT said there is no such thing as an intergovernmental taking because there's no such thing as private property. And I really want to highlight the example we gave in our briefs to show, I think, the absurdity of this argument. If the federal government endowed the Department of Agriculture with the power to build a farm on the Department of Interior's land, the Department of Interior can't sue the Department of Agriculture for a taking. All that's happened is the federal government has reallocated its own property amongst its various constituent arms. And if this court determines, as we think it should, that the Attorney General properly exercised her power to release claims inhering in the state's political subdivisions when acting as the state, all the state has done is reallocated those property interests, those claims, which are the state's, to the Attorney General's control, because she is acting as the state of Florida and has a superior interest. So the takings argument just doesn't work.
So, I mean, it's your contention then, there's construction going on down at the Capitol. If the state decided it wanted the Leon County Courthouse or City Hall, it could just take those and offer no compensation to the city or county.
I want to be careful here because I don't know if there are any statutes out there that would require the state to pay compensation for the exercise of eminent domain in that circumstance, but granting me that there are none, yes. The takings clause would not require the state of Florida to pay cities and counties money to get the state of Florida's own property. If the state of Florida, in other words, has endowed the governments, the state governments, that is, with the power to exercise eminent domain against another state actor, all it has done is given one state actor the ability to reallocate the state's own property, because the city's construction, the county's construction, they're all the state's property. And so that's why cases like the Nebraska case we cite and the Texas case we cite all recognize that there is no private property involved when a county is suing a city for a taking or whatnot. There might be a fight about whether the county or the city actually has the power of eminent domain and whether they actually can exercise the power. That's the fight in the first part of our argument, whether the AG actually has the power to release these claims. But if the AG does have that power, she commits no taking while doing so because she has just exercised the state's grant of authority to her to reallocate the state's property in a way that it thinks is best. Unless this court has further questions, we're happy to rest on the briefs for the discovery argument, and we'd ask that the court affirm. Thank you.
Thank you.
Please the court. As you just heard, the AG's theory has no limiting principle. She assumes her common law power is anything she wants to label the state of Florida. She can, at the wave of a magic wand, wipe away claims of any city, any county, any subdivision at all. But that's not what the cases say. The cases say that her power is when she acts for the state and for the public interest and not anything beyond that. And what the cases say, Engle 2 and otherwise, is that if there's a question of whether a claim is within the state or within the public interest, that's resolved by a res judicata analysis. Your Honor, you asked a question about who decides the public interest, and the AG said, well, that's Barati. We argue it's Engle 2. I mean, Barati was clearly a case brought in the name of the state. There's no doubt it was. It was Keytown. That's the same thing that the recent Pennsylvania case said. It was a claim brought by the state attorney and that he only sues in the name of the state. and so does the AG. So then you have identity of parties. But here, we argue that appellants are not the state, and so we don't have identity of parties. My friend raised this federal immigration lawsuit example and said that a city couldn't drop out of the lawsuit. He's right, if it was just for the state. But then again, the cities would have never signed up for the lawsuit because it's only the state. So Engle 2 addressed this particular situation by referencing a third DCA case called Castro. And in Castro, you had a lawsuit that was both for the city of Miami and the citizens of
Well,
Florida.
actually, the reverse hypothetical that your honorable opposing counsel raised is interesting. If the state attorney general filed an immigration lawsuit against the president of the United States, and Miami-Dade County asserted that its interests were different, that its damages were different, that the state attorney general could not properly represent Miami-Dade County, for example, just as a hypothetical. Under your theory, the city could commence its own suit, I assume, against the Secretary of Homeland Security and/or the president on immigration, right?
That's right. Under our theory, the city could pursue its own suit. Now, it'd have to have standing. It'd have to meet the requirements to be able to bring that kind of action. But if it could, and it did that only for itself, didn't tag on, that this was also for the benefit of the citizens of Florida, which was the situation in Castro, but just did it for the city, then yes. But my friend, in saying that somehow cities and counties can nullify the AG's action against the federal government, that could never happen, because those cities and counties, if she's suing on behalf of the state, wouldn't have ever signed up for it. I mean, they're not a part of it. There's nothing they can do to drop out of, but they could bring a separate action as long as that separate action is for their particularized harms that wouldn't fall within the scope of what the AG has standing to sue for. And that's the difference. Also, just thinking about this situation, there were other ways the AG could have remedied the situation to achieve, the full settlement she seeks. She could have intervened in our state court cases, and she didn't. She could have passed the legislation that she sought in 2001, but it wasn't enacted. And now she seeks this court to do exactly what the legislature chose not to do. If this court agreed with her theory, it would be taking power away from the legislature, because the legislature has not provided to the AG the ability to determine the course of our particularized claims. There's no statute.
Well, you don't put any emphasis on the fact that a bill did not pass, right? That's not precedent for any argument, right?
That's right. That's not precedent, but it was an avenue for her to obtain what she is seeking today.
Right. Lots of bills don't pass.
Yeah. But it is an important point that she would be taking power from the legislature if this court agreed with her theory today. I'll mention the takings clause because I think it's appropriate here. The AG, and just one point, the AG quotes, "What the legislature giveth, so it may taketh away." And we agree. I mean, all of the cases deal with legislative power. City of Trenton's talking about a specific statute that New Jersey had. The Texas DOT case is all about the state legislature having, quote, sole and exclusive control over public roads. So if the legislature has control, then they can move property anywhere they want. But here, there is no legislative action, no specific statute that the AG is relying on. And her common law powers aren't unlimited. Their scope is covered as within the buckets of the state and within the bucket of the public interest. And that's not to say that she doesn't have significant power. I mean, she has standing where no one else has standing in the state. but it has to be within those buckets, and our claims fall outside of those buckets. The court doesn't have any other questions. I'm happy to rest on our briefs.
Thank you both for your excellent arguments. The court's in recess.
All rise.